Good morning. I think we're ready to convene. If everybody wants to take their seats. Because this is an adjudicatory hearing, I handle this a little bit more formally. Today is Tuesday, October 29th, 2013. This is a Phase 1 suitability hearing before the Massachusetts Gaming Commission relative to the application of Sterling Suffolk Racecourse, LLC. My name is Steve Crosby, and I'm the chairman of the commission. I'm joined today by Commissioners Cameron, McHugh, Zuniga, and Stebbins. By way of clarification, we also have called at 3 o'clock this afternoon a special meeting of the commission to discuss the issue of the referendum in Revere and Boston on November 5th, given the changes in circumstances in the last few days and weeks. That's a separate matter, but we will be discussing that at a separate meeting, which will begin at 3 o'clock this afternoon. The entire commission will preside over this hearing and the decision of this matter. This is an adjudicatory proceeding which is convened in accordance with 205 CMR 115.04, paragraph 3, and will be conducted pursuant to the formal rules outlined in 801 CMR 1.01, subject to the clarifications contained in 205 CMR 101.03 and Chapter 30A of the General Laws. Before we begin, I'd like to explain the procedural history that led us here, as well as the process that will govern the proceeding. Sterling Suffolk Racecourse, LLC, submitted a Phase 1 application to the Commission. The Commission then instructed the Investigations and Enforcement Bureau to commence an investigation into the suitability of the applicant to hold a gaming license in Massachusetts. The Bureau has conducted such an investigation into the qualifications and suitability of the applicant and its qualifiers, and generated an investigative report of its findings, which it submitted to the Commission. A copy of the report was also provided by the applicant, to the applicant by the Commission. Based on the report, the Commission has scheduled this proceeding on its own initiative. I see that a number of lawyers are present here today, as usual. On behalf of the applicant and the Bureau, I will ask that you each please identify yourself and advise the Commission as to whom you represent. All lawyers at work.
Yes, good morning, Mr. Chairman, Commissioners. David Mackey and Nina Pickering-Cook from the law firm Anderson & Krieger, representing the Investigations and Enforcement Bureau this morning.
Good morning, Mr. Chairman and Commissioners. My name is Bruce Falvey from the law firm of DLA Piper, representing the applicant, Sterling Suffolk Racecourse, LLC.
Anybody else?
Yes, Thomas Riley from the law firm of Cooley Mannion Jones, representing the applicant, Sterling Suffolk.
Anybody else? Thank you, Counsel. At the conclusion of my opening comments, this proceeding will commence with a recitation and explanation of the investigative report by the Bureau. We will ask that the Bureau outline the manner in which the investigation was conducted and outline the findings relative to each qualifier. The Bureau's presentation will largely be made by Karen Wells, who is the director of the Bureau. Director Wells is joined by the consultants from the Spectrum Gaming Group, who assisted in the conduct of the investigation. We will allow the consultants to offer any clarification or answer any questions during Director Wells' presentation. Any commissioner may ask a question of Director Wells or a consultant at any point during or following her presentation. At the conclusion of the Bureau's presentation, the applicant, through its counsel, will be afforded an opportunity to cross-examine the Director Wells or a consultant relative to any information contained in the investigative report or to which they testified. The applicant may reserve its right to cross-examination until the end of their own presentation if they so choose. Next, the applicant will be given an opportunity to present its case. The burden is on the applicant to demonstrate by clear and convincing evidence both its affirmative qualifications for licensure and the absence of any disqualification for licensure. To that end, the applicant has already subjected itself to a thorough background investigation, the results of which are set out in the investigative report. Those findings will be considered in determining whether the burden has been satisfied. For purposes of this proceeding, however, the applicant may call any witnesses and present any other evidence it desires in an effort to satisfy its burden. The Commission has directed that at a minimum, Joseph O'Donnell, Richard Fields, William Mulrow, Paul Tuttle, John Irizzo, and Charles Baker be available to present testimony as to the issues set forth in the notice of this hearing that was provided to the applicant. I understand that counsel for the applicant had an opportunity to meet with counsel for the Bureau and Commission to discuss this proceeding. The purpose in part was to clarify some of the issues that the applicant should address in its presentation. Those are primarily the issues that will be set forth in the written notice of this hearing. Is that correct for all of you?
Yes, it is.
The meeting and the understanding of the issues.
There's one slight correction, Mr. Chairman. Mr. O'Donnell unfortunately was unable to be here today, and we had informed counsel for the Bureau, and they indicated that, they understood that.
And that was acceptable?
Correct, yes.
Okay. While those areas should be included in the applicant's presentation, it may certainly address any other issues it believes may be relevant to its suitability determination. Similarly, the commissioners may certainly inquire into any issue that is of interest to us. At the conclusion of each witness's testimony, counsel for the Bureau will be provided an opportunity to conduct cross-examination of the witness. Then each commissioner will be afforded an opportunity to ask questions of the witness. Any commissioner may, however, ask any question of any witness at any time during an examination or at the conclusion of the examinations. We will allow very limited redirect and recross of a witness if it is absolutely necessary. Either party may raise objections they desire at any time. The basis for all objections must be clearly stated. Finally, at the conclusion of all of the evidence, the applicant will be provided an opportunity to make a closing statement summing up why it believes that it is suitable to be issued a gaming license and should be allowed to proceed to the Phase 2 portion of the process. Before we begin, understand that there are a number of pre-marked exhibits that have been exchanged by the parties in advance of this hearing. I'll now ask the Bureau's counsel to introduce the Bureau's exhibits.
Yes, sir, Mr. Chairman. We have conferred with the applicant's counsel and agreed upon and pre-marked 6 exhibits, marked Bureau's exhibits 1 through 6. Exhibit 1 is the notice of the adjudicatory proceeding. Exhibit 2 is the memorandum regarding how this proceeding will be conducted. Exhibit 3 is Director Wells' cover letter. Exhibit 4 is a redacted copy of the investigative report. Exhibit 5 is a letter from the applicant to Caesars Massachusetts Investment Company dated October 18th, 2013, and the final exhibit, pre-marked Exhibit 6, is a letter from Caesars Entertainment Corporation to Chairman Crosby dated October 21st, 2013. I do not believe there are objections to the introduction of any of these exhibits.
Are there any objections to these exhibits being marked and
No
entered in
objections.
evidence? Okay. Now, if the applicant has any exhibits it would like to introduce, I'd like to ask that they be introduced.
Thank you, Mr. Chairman. We have pre-marked 2 exhibits, to which I believe there are no objections. Sterling Suffolk Exhibit number 1 is its plan for finding a new operator, and its Exhibit number 2 is its check cashing policy and procedures. And we offer those into evidence.
Thank you. Are there any objections to these exhibits being marked and entered into evidence?
No objections.
If either party would like to have any additional documents entered into evidence during the course of the hearing, I would ask that they be properly introduced and marked by the court reporter. The Commission anticipates that its inquiry at this proceeding will be limited to the matters addressed in the investigative report. In the event that a line of questioning conducted by the Commission or Bureau moves into an area that has not been included in the report, but that is included as part of the investigative file and is material to the suitability determination, the applicant may request a recess in the proceeding so as to review the issue. This would be unlikely happenstance, however, as the Commission anticipates addressing solely issues covered in the investigative report. No final decision will be made at the conclusion of the hearing today. Instead, the matter will be taken under advisement at the conclusion of the proceeding and a written decision issued. If at any point during the Commission's deliberations it determines that further testimonial or documentary evidence is desirable, it reserves the right to ask the applicant to provide such evidence prior to a suitability decision being made. We will now swear all of the witnesses in. Anyone who will be testifying at this proceeding, please stand and raise your right hand. Do you solemnly swear that the testimony you will provide before the Commission at this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Each have answered in the affirmatively. Thank you all. All have responded in the affirmative. Before we begin, does either counsel has preliminary issues or objections?
No, sir.
Considerations? With that, I'll ask Attorney Mackey to begin the Bureau's presentation.
Yes, thank you, and good morning. The Bureau will begin its presentation with a summary from Director Wells of the investigative report dated October 18th, 2013.
Thank you, Attorney Mackey. Good morning, Chairman Crosby and members of the Commission. As a preliminary matter, I would like to thank our contract investigators from Spectrum Gaming. Present today here are Steve Ingus, Mike Lamantia, and John Zvinkowski, and the IEB staff, particularly Loretta Lilios and the members of the Massachusetts State Police, led by Detective Lieutenant Brian Connors and Lieutenant Kevin Condon, who worked so diligently on this investigation, as I am sure is evidenced by the comprehensive and thorough report that was provided to the Commission. We took this investigation very seriously, as was our duty to the Commission and to the people of the Commonwealth of Massachusetts. On January 15th of 2013, Sterling Suffolk Racecourse, LLC, hereinafter I will refer to as SSR, filed an application for a Category 1 gaming license in Region A. SSR was formed on June 30th, 1997 for the purpose of acquiring, developing, and operating property containing approximately 163 acres with improvements located in Revere in East Boston, known as Suffolk Downs, a thoroughbred horse racing facility. The only gambling business that SSR conducts is parimutuel wagering on horse racing. Licenses have been granted annually since 1992. They are also a Massachusetts lottery agent with its license in good standing. SSR utilizes a formalized employee code of conduct and also has an employee and vendor background program in place. Both the applicant and the former qualifier, Caesars Entertainment, have notified the Commission that Caesars will no longer be a gaming operator for the proposed casino and that Caesars is withdrawing as a qualifier. As such, my remarks will not detail the substance of concerns regarding Caesars that were addressed in the IEB report and my cover letter to the Commission. Procedurally, on October 2nd, 2013, the IEB met with representatives from the applicant entity as well as the qualifier Caesars Entertainment Corporation to review concerns uncovered during the investigation and to give the applicant an opportunity to respond before the report was completed. It appeared to me at that time that the representative from SSR, Attorney Baker, who's present here today, was being apprised of some concerns regarding the Gansevoort matter for this first time during this meeting. On October 9th, 2013, the IEB again met with representatives from the applicant entity as well as the qualifier Caesars Entertainment Corporation regarding the identified issues of concern, including the Gansevoort matter. At all meetings and in all conversations with the applicant representatives, I emphasized that the report would contain facts and a recommendation only, and that the final decision on suitability rests with the Commission itself. On October 15, 2013, Charles Baker, Secretary for Sterling Suffolk Racecourse, sent an unsuitability notice regarding Caesars to all of its members. On October 18, 2013, I submitted the report and the cover letter to the Commission. That same day, on October 18, 2013, Chip Tuttle sent letters to Caesars requesting they resign as manager under the agreement and take such steps as necessary to cause the removal of Caesars from the SSR gaming license application. On October 21st, 2013, Caesars submitted a notice of withdrawal to the Commission. That was before the hearing notice was sent. I expect that the applicant will address the withdrawal of the gaming operator as part of their presentation to the Commission. Additionally, as Caesars was to be in charge of compliance, the applicant, I expect, will address that as well, going forward what the plan is for the proposed casino operation. I expect that once the presentation is made to the Commission, there'll be no reason to contest the withdrawal of Caesars. It should be very clear on the record that the Commission itself has taken no action with respect to the suitability of Caesars at this time. The applicant plans to locate the proposed casino at the site of the Suffolk Downs racetrack in East Boston. On August 27, 2013, SSR announced that it had reached an agreement on the requisite host, regarding the requisite host community agreement with the City of Boston. An election has been scheduled for November 5th of 2013 for the host community to vote on whether it favors the issuance of a Category 1 gaming license to the applicant. Discussion about those issues, as the chairman has indicated regarding that vote, is scheduled for 3 o'clock today, and that's a separate matter and will not be part of the suitability hearing. The principal entity members involved in SSR include the Coastal Development Ownership Group, which is owned and controlled by Richard Fields, as well as the O'Donnell Group, which is owned and controlled by Joe O'Donnell. Coastal Chairman Richard Fields formed the company in 2005 to finance and develop resort properties, entertainment venues, and casino gaming facilities. In early 2000, Fields co-developed the Seminole Hard Rock Casino with the Cordish companies in both Tampa and Hollywood, Florida. His interest has since been bought out by the Seminole Tribe of Florida, and he no longer holds any interest in that project. Through the Coastal Group, he is currently the majority shareholder of SSR. Fields intends to grow Coastal through the acquisition, development, and repositioning of new and existing properties. The report identifies his net worth as dependent on the successful gaming awarding of a gaming license to SSR. It is important to note, in the event SSR receives a license, Field will be able to demonstrate his financial stability. If not, the matter actually becomes irrelevant to the commission. As for the O'Donnell side of the investment group, the 6 O'Donnell Group ownership companies filed applications with the commission as qualifiers as a result of their ownership in SSR are non-operating entities and do not conduct any gaming business. Similar to Coastal and Fields, these entities are all owned and controlled by Joseph O'Donnell. Accordingly, their suitability is tied to a finding of suitability for O'Donnell. The company started acquiring an ownership interest in SSR in 1997 and acquired their current ownership interest prior to the legalization of casino gaming in Massachusetts in November of 2011. The entities pursued their ownership interest in SSR because O'Donnell thought it was a good long-term real estate investment. Through the course of the investigation, Mr. O'Donnell demonstrated the financial stability and integrity, honesty, and reputation necessary to qualify for licensure. Some of the other entities that were investigated as subgroups of these 2 ownership interests included Coastal Development SSR LLC, Suffolk CCF LLC, Fisher WWCD Investors LLC, Sterling Racecourse Inc., as well as SSR Investor LLC, JJO Sterling Suffolk Inc., and 6th Street Sterling LLC. Vernado Suffolk LLC is a percentage of interest which is presently held in trust by Stephen Kidder, a Boston attorney. Individuals deemed as Vernado's qualifiers during the scope of licensing process decided not to submit to regulatory filing requirements. Vernado was required by the IEB to place his entire interest into a divestiture trust, and upon doing so was deemed by the commission to no longer be an entity of the applicant. Stephen Kidder, the trustee, however, was deemed to be a qualifier and was required to submit to the entire background process. Only Kidder has decision-making authority over the current interest, and there were no issues regarding his background investigation found during the process. Other minority interests in the applicant entity include Dreamport Suffolk Corporation, Rulame Family Trusts, MAR Suffolk LLC, and Hall Racecourse Properties, Inc. The IEB waived the qualification requirements for the non-voting entity members, SSR Investment Trust 1, SSR Investment Trust 2, Dreamport Suffolk Corporation, Hall Racecourse Properties, and MAR Suffolk, since they all held 2% or less interest in the applicant. Additionally, Caesars Entertainment Corporation holds a minority interest in the applicant through a subsidiary company, Caesars Massachusetts Investment Company, LLC. The applicant will need to address the issue of that ownership interest as part of their application. For clarification, when the applicant submitted its original business entity disclosure on December 6, 2012, Suffolk CF LLC was owned 60% by Coastal Development SSR and 40% by Fisher WWCD Investors. On January 10, 2013, the applicant advised the IEB the structure of Suffolk CCF had changed and was not solely owned by Coastal Development SSR. As a result of the restructuring, Fisher is now a 2% direct owner of the applicant, and the IEB waived qualification requirements and removed the entity from the list of qualifiers. The applicant has a board of managers that are appointed by the voting member entities that comprise the applicant. There are currently 6 managers. William Moreau, he is the chair, appointed by Sterling Racecourse. Joseph O'Donnell, appointed by 6th Street Sterling, LLC. Charles Morneau, appointed by a plurality vote of O'Donnell, Coastal Group, and Vernado, that voting entity represented by Stephen Kidder. John L. Hall II, appointed by Coastal Development, SSR, Robert Vincent, appointed by Cambridge Suffolk LLC, and then Stephen Kidder, a trustee of the Bernardo Divestiture Trust. The applicant will have to address whether or not the new operator will have a seat on the Board of Managers. Officers of the applicant are John Hall II, President, Paul M. Chip Tuttle, COO, John Rizzo, Treasurer and CFO, and Charles Baker, Secretary. SSR's financial stability is dependent on the continued funding and support of its members and also reliant on the positive outcome of their negotiations with financial institutions to fund their proposed casino project. Investigators concluded that the applicant would possess the requisite financial stability upon the award of the casino license to SSR. SSR anticipates that the budget for the casino project would be approximately $1.1 billion. The project would be funded from the members' equity in the applicant and expected loans from financial institutions. Joseph O'Donnell and CMIC representatives have represented they would cover any unanticipated shortfall in the event another member is unable to meet capital call obligations. The applicant has started preliminary negotiations with financial institutions in order to gauge their interest in funding the casino project. Initial feedback from the preliminary negotiations indicates the institutions will loan up to 3 to 3.2 times the projected EBITDA of the operating casino. Under these parameters, SSR would meet its goal of funding 75% of the project from financial institutions. As with all other applicants, any financial sources identified in Phase 2 of the process would need to be fully vetted by the IEB. Given the length of the report and the numerous number of qualifiers, I will defer to the report for the Commission's consideration on the specifics. But each entity and all their qualifiers were investigated thoroughly, and the investigation did not reveal any significant derogatory information relating to any of the individual qualifiers or other entity qualifiers as the applicant now stands. The entities and qualifiers have demonstrated by clear and convincing evidence that they are suitable for licensure. The IE recommends that the Commission find the applicant, Sterling Suffolk Racecourse LLC, suitable for licensing, subject to the following conditions. 1, the applicant must identify for the Commission the new operator of the proposed casino project. Obviously, my expectation is not that they would have to do that today, but I would defer to the Commission's consideration on a timetable for that. 2, the new operator and any qualifiers must be found suitable by the Commission. And 3, the applicant must present a plan to the Commission for working with the host community to bring on a new operator. As stated in 205 CMR 11503 through 05, the IEB is only providing a recommendation, and the final determination of suitability rests within the Commission's sound discretion. Additionally, as with other applicants, the IEB suggests that if the applicant is awarded a Category 1 license, the Commission consider adding the following conditions to the actual license. 1, the applicant shall promptly report any changes relating to their ownership, members, managers, and/or directors. Any new owners, members, managers, and/or directors should be required to submit a PhD or MassUp or BED form to the Commission, and that any other owners, members, managers, and/or directors must be found suitable. Additionally, I won't read the entire recommendation, but given the nature of the casino industry and their concern regarding money laundering, we would ask that they submit any kind of information regarding money laundering practices and compliance with the Bank Secrecy Act to the Commission for approval. So that concludes my remarks this morning.
Just one moment. Michael, would you make sure that the web feed has identifying factors, what's going on and who's speaking, so our web audience can see? There's usually, okay, it hasn't been up on the feed here. So just want to make sure that our web audience knows what's going on. Thank you. Mr. Mackey, other questions for
Nothing further from the Bureau at this time.
okay. Any questions?
We have no questions, thank you.
All right. Nothing from the commissioners? No back and forth? So I guess we are ready to move to the applicant.
Thank you, Mr. Chairman. As you know, I represent Sterling Suffolk, commonly known as Suffolk Downs. On behalf of Suffolk Downs, thanks for the opportunity to appear before you. Thank you also to the commission staff for their cooperation preparing for the hearing and throughout this process. Our 4 witnesses are seated with me this morning. To my far left is Charlie Baker, longtime Secretary of Suffolk Downs. To his right is Tom Riley, former Massachusetts Attorney General, the company's special counsel. He was retained to assist Suffolk Downs as we learned of and took action concerning the suitability issues of our former gaming operator, Caesars Entertainment. To his right is Chip Tuttle, the Chief Operating Officer of Suffolk Downs. And to his right and my left is Bill Mulrow, the Chairman of the Board of Managers of Suffolk Downs. We understand that we have the burden of proving suitability by clear and convincing evidence. Our presentation is focused on the issues listed in the Commission's notice of adjudicatory proceeding. First, Mr. Baker will walk you through the due diligence that Suffolk Downs did with respect to Caesars when Suffolk Downs brought them in as our operator, what we learned about Caesars as a result of the Bureau's investigation and when we learned it, and what we did in response to that information. At that point, to expand on the chronology, you will hear from Mr. Riley. He will report in greater detail on how he was brought in as special counsel to the company as soon as we learned about the Caesars issues, and he will explain how we handled the Caesars matter. With the Commission's permission, we'll then go back to Mr. Baker, who will finish up by addressing the status of Caesars separation, how the company plans to find a replacement operator, and its plans for working with its host communities during that process. Our third witness will then be Mr. Tuttle, our COO. He will explain in greater detail the community process that we've already undertaken to inform our host communities and their residents about Caesar's departure. And finally, Mr. Mulrow, our chairman, will address Suffolk Downs' unwavering commitment to the project and to its host communities. In addition to these witnesses, and in compliance with your notice and the memo about this hearing, several other company representatives are here and available for questions. Present and available are John Rizzo, our CFO, Richard Fields, the Principal of Coastal Development, and Jeremy Kleiman, who is General Counsel to Coastal. After you hear from our witnesses, I will give a very brief closing. We understand that the Commission prefers hearing from the witnesses directly, so I'm not going to dispense with questions and answers, and simply at this point turn the microphone over to Charlie Baker.
Thank you, Bruce. Mr. Chairman, members of the Commission, my name is Charles Baker, and I'm the Secretary of Sterling Suffolk Racecourse, LLC, the applicant before you. I've had the privilege of serving in that role since Sterling Suffolk took over Suffolk Downs in 1991. At that time, Suffolk Downs had been closed for a year and a half, and the country was right in the middle of a recession. By returning thoroughbred racing to the Commonwealth, the owners of Sterling Suffolk were able to put back to work hundreds of direct employees and thousands of other individuals involved in the horse racing industry who had no employment prospects during that period. Since then, Sterling Suffolk's owners, mindful of the track's 78-year history as a gaming location, have taken steps to expand and improve its long-term viability, including by seeking a gaming license and being a candidate for suitability before you today. I'd like to thank Director Wells and the Bureau for the very careful and thoughtful investigative report which they have presented to the Commission in regards to Sterling Suffolk's suitability. As I think you know, Sterling Suffolk was involved prior to the passage of the Gaming Act and the creation of the Commission and the public policy discussions about expanded gaming in Massachusetts. I can say with certainty, having followed that debate closely, that it is very important that you establish standards that meet the values and beliefs of the people of the Commonwealth. Many have observed that there is a reason that Massachusetts was one of the last states to license casino gaming. The public demands that this be done right. In this light, the Bureau and you should be commended for the diligence which you have pursued your collective role of ensuring the integrity of the industry. There are a few items in the report I'd like to address, and then I will be available, as we all will, for questions that you may have. Until this month, Sterling Suffolk had 62 qualifiers, 27 entities and 35 individuals, far and away the largest number of any applicant. Even after the withdrawal of the Caesars qualifiers, we still have 23 qualifiers before you today. This includes 13 entities and 10 individuals who have completed the extensive forms supplied thousands of pages of additional documents, and sat through detailed interviews with your investigators. I'm pleased to note that all of the other remaining qualifiers received positive suitability reviews. Turning to the Caesars issues, I will address one, Sterling Suffolk's due diligence at the time Caesars joined the company as our prospective operator, two, what we learned about Caesars and when a result of the Bureau's investigation, how we handled that information, how the company plans to find a replacement operator, and the plan for and the status of the company's separation from Caesars. As it relates to a more specific timetable of recent events about Suffolk's response to the Caesars suitability issues, I will defer to Tom Riley, but will of course be happy to answer any questions on the topic based on my direct knowledge. First, I know there have been inquiries about what due diligence Suffolk conducted on Caesars. Back in 2011, when Suffolk was searching for gaming operator, we talked to a number of high-profile participants in the industry. In regard to Caesars, we obviously understood that Caesars was licensed in all the major gaming jurisdictions. As the report notes, Caesars operated 52 facilities in 12 states in the U.S. and 7 other nations as of the end of last year. We also knew that Caesars was engaged in a licensure process in Ohio. We insisted that we were updated throughout that process as to their status in that suitability review. Prior to Massachusetts, Ohio was the most recent state that had authorized gaming, and Caesars' suitability review in Ohio was meaningful to us. We also reviewed Caesars' contemporaneous SEC filings for any material information. As it relates to Caesars' financial stability, the business advisors of both principal shareholders, Belmont Capital and Coastal Development, reviewed carefully Caesars' plans to finance the projects that they were undergoing in Ohio. They also talked to relevant investment banking sources. Based on the success of those Ohio transactions as they were going through at the time, it became apparent that Caesars' financial condition had no negative effect on its ability to do project financings. This was important to us because, as the report outlines, similar project financing will likely form the basis of the finance plans Sterling Suffolk will present in its RFA 2 response. We also addressed suitability issues in our contracts with Caesars. Both the Gaming Facility Management Agreement and the company's LLC agreement have provisions that require Caesars to disclose licensing issues to us and empower Suffolk to take action in the event a suitability arises, as it has occurred in this case. Additionally, we informed our then regulator, the Massachusetts Racing Commission, of the proposed transaction. We specifically sought approval by the Racing Commission of the addition of John Payne, the Caesars designee, to the company's Board of Managers, which functions as our Board of Directors. We submitted Mr. Payne's background information to the Racing Commission State Police Unit. They investigated Mr. Payne's background and recommended approval to the Racing Commission. The Commission acted favorably on that recommendation. The second issue I would like to address is the events leading to the departure of Caesars as a qualifier. As Director Wells noted, in our first formal meeting with the Bureau concerning our suitability report on October 2nd, we first learned of significant and negative concern around a specific transaction Caesars had entered into. The transaction at issue, I should note, occurred after Caesars was hired to be our operator. Upon being made aware of the matter, we immediately requested all relevant documents from Caesars, and I was directed by the Board of Managers to retain Tom Riley as special counsel to lead our independent review of the matter. For purposes of keeping the chronology intact, with the Commission's assent, I'd now like to turn the microphone over to Tom.
Mr. Chairman, members of the committee, commission rather. First of all, thank you for the opportunity. Thank you for the opportunity to appear before you today. I'm very mindful of the fact that Caesars is no longer part of this process, so I will try as best I can to limit my remarks to what Suffolk did, and I'll refer to it as Suffolk. That's how we kind of think of it. As to what they did, once they became aware, or Charlie became aware, that there were some serious concerns about the suitability of Caesars. I believe the record will reflect that Suffolk acted very quickly and decisively and handled this in a very responsible manner. But I understand that's your decision, and you will make that decision. So why don't I just tell you what happened, at least from my perspective. As Mr. Baker has told you, October the 2nd, he first became aware that there was concerns and that the Bureau staff had concerns over the Gansevoort matter. The next day, I was retained as
And others.
Pardon?
You said Gansevoort, but there were a variety of issues that were on the table at that meeting, right?
That is correct, and I'll get to those. But the next day, I was retained by Suffolk as special counsel to review, and frankly, given my marching orders by Mr. Fields and Mr. O'Donnell to get to the bottom of this, to see whether or not and determine whether or not there was anything to these concerns, and then report back to the company. And that's exactly what I did. The next day, the first thing that I did was a telephone call to Director Wells and asked her about the concerns. She, at that point, flagged certain documents and directed me, or not directed me, but certainly indicated that I should be familiar with the Goldstock report and the Cachet report, which were in the possession of the commission and form part of the basis for what their concerns were. Those reports had been requested by Mr. Baker after the meeting on October the 2nd. Caesar, for whatever reason, did not furnish those documents. I was immediately in contact later that afternoon and evening with Caesars. I requested those documents, and late that night, I received those documents, explaining to them exactly what the situation was. First of all, I was not able, because of the late hour, to address those documents that night. 3-hour time difference, they came in very late. But I did have the opportunity the following day, on October the 5th, on Saturday, to review the documents, the Goldstock and Cachet reports, and other related documents from Caesars. I reviewed them thoroughly, and it was obvious there were red flags. There were things that frankly jumped out of those reports at me, at that point, it was clear to me that the concerns that the Bureau had identified were legitimate concerns, that these were serious matters, and at the very least, Suffolk should follow up on these allegations and get as much information as we possibly could as soon as possible. I should note that it was obvious to me in my conversations with Mr. Baker, also with the principal owners, Mr. O'Donnell and Mr. Field, this is the first that they were really hearing about specifics of real, legitimate, serious concerns. Now, after having that material on October the 5th and having the opportunity to review that material, the week of October 7th was an intense experience as I tried, and when I say I, this wasn't a one-man show. Mr. Baker and his team were part of this. Mr. Mannion and Mr. Fazio from Cooley Mannion Jones were part of this. What we're trying to do is get as much information as we possibly could to follow up on the reports and the concerns of the Bureau. Now, at that time, I became aware of there were additional matters, as you have referred to, Mr. Chairman, the Watanabe matter being one of those. I became aware, because the Commission advised me that they would be seeking certain internal reports concerning that matter. And they did request that from Caesars. I made the same request, but Caesars refused to give us the internal investigations that they conducted. Now, when I say that, in fairness, I was given an oral briefing on Watanabe by Caesars. In our meeting on October the 9th with the Bureau staff, that matter was discussed openly, and although I don't have, and we were not given access to the internal reports, I do believe and am comfortable that I know enough about that situation to be able to do my job and certainly advise the company. Now, during the course of that week, there was a meeting, as I said, as I've noted, on October the 9th with Bureau staff. I also became aware of the situation involving Mitchell Garber. Now, in the report, it's clear there are some financial concerns as well. I was not involved in any of that. I had numerous meetings and conversations with Caesars involving these matters. I followed up as best I could with your staff and the Bureau staff. I have to say that they were extremely forthcoming to everyone and straightforward to everyone. Everyone was on notice, okay, that the Bureau had some serious concerns and what those concerns were. Everyone was on notice going into this that the final recommendation had not been made by the director, and when it was made, it would be conveyed to the commission first. Although there was no hiding back that there were serious concerns. The third thing that was made very clear to everyone involved in this, that this was the Bureau's recommendation, and their recommendation only, and that the final decision rested with you. And if anyone disagreed, wanted to challenge or debate it, certainly they were free to do it. So as that week neared an end, and I'm talking about the week of October 7th, everyone was on notice, and I truly believe everyone had the same information. Not only did I continue to brief Mr. Fields, Mr. O'Donnell on where matters stood, I briefed a segment of the certain members of the board of directors of Caesars as well as their management, as to my opinion as to where things stood, and that was by the end of the week. I think that was on the 11th, I think, in the afternoon of the 11th. But things were still moving, and there had been no final decision as far as I know. But there were concerns, and I had concerns. And quite frankly, if I didn't mention it, the fact that we were given that information, it first disclosed really the specifics of it on that Saturday for the first time, the details of it, and the fact that Mr. Baker was surprised at that meeting of October were very troubling to me, and quite frankly, I conveyed that to everyone. In any event, that week drew to a close. I had briefed Caesars. I had briefed everyone, and I thought that, listen, you always want more information, but I felt that by the following Monday on the week of October the 14th, that we had enough information, and everyone had enough information on our side to make some decisions. And in terms of the partnership and the principal owners, Caesar's going to make whatever decisions they were going to make. But the owners and the principal owners, and Mr. Fields and O'Donnell, had to make some decisions on their own, and we had enough facts as to whether or not they wanted to continue this relationship with Caesars as a qualifier, as a manager, an operator, and given everything that had occurred. On October the 15th, they made that decision, and they made that decision, I think, decisively. Obviously, there are contractual responsibilities that they had to follow, but they filed a notice and gave Caesars a notice of unsuitability, declaring there had been a licensing event. And that occurred on October the 15th. It was the time to start making decisions to begin the end of this relationship, and that decision was made by the principal owners and made willingly. On 3 days later, the the Bureau, issued its report, which speaks for itself. It's very comprehensive and very thorough, and you can see it, and I'm sure you've read it. Within hours, I think within perhaps 3 hours of that, there was a letter that was actually sent by Mr. Tuttle asking Caesars to resign in view of what has happened. There have been skirmishes back and forth since, as you would expect in a situation like this. But the bottom line is the bottom line. Caesars is gone and will not be part of, is not part of this application, and will not be part if the Suffolk is fortunate enough to receive a license to be part of any operation. So those are the facts. As I know those facts, this is what I know. This is what I believe happened and how it happened, and I'm certainly open to answering any questions that you have. And I would just close with this. I want to commend Director Wells and her staff for being upfront with everyone in terms of where matters stood. Then everyone had to make their own decisions, which has brought us to this point. Thank you for your consideration.
Anything from the table at the moment?
Mr. Baker, do you want to, I think Mr. Baker was going to
Finish his
provide some
testimony?
more information.
All
and I
right,
could-
let me just ask one thing, Mr. Riley. First of all, I appreciate your going through the history of this and the timing of this, because I think it's important for people to understand who knew what when. The report makes clear that our Investigations Bureau raised the issue, at least of the Gansevoort question, with Caesars with some significant force in April, 6 months ago. Did anything transpire? I guess this is for you as well as Mr. Baker. Did any communication transpire between Caesars and Suffolk between the time we raised it, our Bureau raised it with Caesars in April and this October 2nd meeting?
No, and I'm glad you asked that question, because that troubled me greatly. There was absolutely no question that in April of this year, that the Bureau staff, their investigators, and state police, I believe, raised this issue at Gansevoort at a meeting in Las Vegas, and that people were interviewed regarding that. So Caesars knew full well that this was a serious matter. Now, Caesars did respond in writing to Spectrum, and I think there was I'm pretty sure there was a copy to the Bureau. Nothing to Suffolk. And Suffolk was totally in the dark as to this matter until Mr. Baker, sitting in a meeting on October the 2nd, heard it for the first time, and quite, there's no need to be surprised by something like this, but that's exactly what happened. And what happened was that Suffolk was blindsided by this, but acted very quickly to deal with it.
Okay. Commissioners, before we go back to Mr. Baker, anything else specifically for Mr. Riley? No. Okay, thanks. Okay.
Thank you, Mr. Chair. I know the Commission would like to understand the process a company is undertaking to find a suitable first-class gaming operator. On Friday, we sent to General Counsel Blue a written description of that process, and it has been made Suffolk's Exhibit 1 in this proceeding. Let me briefly outline it. When Caesars agreed to the company's request on October 18th that they withdraw as an operator, we immediately began contacting and receiving inquiries from many gaming companies from across the country. Some of the companies we have talked to have been found suitable in Massachusetts already. Some have filed here but not yet completed the process, and some would be new to Massachusetts. As we talk to each of them, we are guided by 4 principles. 1, finding a first-class operator. 2, honoring our commitments we've made to a variety of stakeholders, in most particular our host communities. 3, ensuring suitability for licensure. And 4, coordinating with our communities and notifying the voters in those communities in real time. I'll just say a few words about each one. Finding a first-class operator. Sterling Suffolk is committed to finding a first-class operator who will achieve the highest standards of quality, integrity, and patron experience. 2, honoring our commitments. The new operator will have to agree to be bound by Sterling Suffolk's commitments to our host community as expressed in the host community agreements, as well as our existing agreements with impacted live entertainment venues, any future agreements with surrounding communities, and all other commitments Sterling Suffolk has made to our community and its stakeholders. We will require disclosure of any existing suitability issues as part of our due diligence and include in our agreements provisions that mandate reporting to us of any issues that arise in the future, whether here or in other jurisdictions where the operator may be licensed. As we go through the search process, we will work in real time with the IAB to ensure that we're appropriately conducting our own due diligence. In regard to that, in real time, when we've been talking to people who are in your process, we've notified the Bureau and the Commission staff. We have sought permission from people who are in the qualifying process but who have not yet been qualified to waive the confidentiality rights they have and to allow us, with them present, to get a briefing from the Bureau as it relates to suitability. So in real time, we have knowledge of any underlying matters that would affect things. I guess I will tell you, we've learned from an experience and we're tightening up our procedures. The fact of Caesar's withdrawal has obviously been a significant news event in our host communities. Nevertheless, between this development and the election on November 5th, we will continue to conduct a thorough public outreach effort to inform the residents of our host communities of the development. Chip's going to go into that in great detail because he's been living it for the last number of weeks. But what I'm going to say is the following. We are not going to ask our host communities to take our word for it that the new operator will commit to the requirements of the HCA. The City of Boston and the City of Revere have already expressed to us their interest in vetting the new operator so they can satisfy themselves that the agreements will be kept. We will do what it takes to allow them to do that. Along the way, we will consult regularly, and not less than weekly, with the host communities about the status of our search. Sterling cannot promise that we will be able to find a new operator by the host community elections next Tuesday, but we are confident we will find a new one well in advance of the December 31st RFA 2 deadline, and we will present a joint application for our outstanding resort casino. I was also asked to update you on the current status of Caesars. Yesterday, John Payne notified us, and we relayed to the Bureau that he's resigned as a member of the Board of Directors. And yesterday, we terminated the GFMA, the Gaming Facilities Management Agreement with Caesars, and removed any control rights or privileges that they have over the entity. They remain a 4.2% owner of the company, and we would respectfully request that we can work with the Bureau and your staff and ultimately get your guidance as to how we can work out an orderly divestiture of that interest. Before concluding, I'd like to mention, three, because I guess Karen wants me to talk about our ongoing compliance efforts. Three non-Caesars points raised by the Bureau's report and recommendation letter. Let me first talk about our going forward compliance matters. First, as I think you may know, just as a racetrack, we have a first-rate compliance officer, Paul Evans, who does a really terrific job, in my view, of working at the facility with your staff, with the state police unit, and ensuring compliance. That remains in place, and Paul reports regularly to Chip and to me on any matter that may rise to the level of needing some judgment and action. Our plan for compliance on a going forward basis remains as follows, and we're going to need your guidance on this, and if we're lucky enough to earn your trust in getting a license. The board has authorized the creation of a compliance committee for Sterling. Our view is would have three independent members of that committee, knowledgeable in law enforcement, finance, accounting, the relevant disciplines. We would seek your approval for the identity of those people. When we get an operator, we're going to need to work out a protocol for coordination between that operator and our compliance committee and the Bureau, so that in real time we can all manage things appropriately. Because we don't have an operator and because we're going to need your and the Bureau's guidance, that's about as far as we've gone in sort of thinking through this. But as I said, the company has taken the necessary corporate actions to implement whatever recommendations the Bureau and you would require. Two other things in the report that I just want to bring to your attention, and one of these actually relates to Paul Evans. I was pleased that the Bureau noted at page 37 our implementation of what we think is a first-class employee code of conduct. The code of conduct requires that our business be conducted in the most ethical manner and that our employees seek to achieve for the company the highest degree of respect and esteem of the public and of those with whom we do business. Second, I note that for all applicants, including Sterling Suffolk, the Bureau has recommended as a condition of licensure, not suitability, that the applicants submit and adhere to a plan for compliance with the Bank Secrecy Act. I'm pleased to be able to report that Sterling Suffolk has already moved proactively to adopt such a policy to address our current operations. Incidental to our racetrack and pari-mutuel wagering business, Suffolk sometimes cashes checks for patrons and employees. Even as this incidental check cashing could conceivably trigger Bank Secrecy Act registration reporting requirements for a financial institution, in 2012, Sterling had us conduct a review of its check cashing policy practices for compliance with the BSA. The review found no indication that the company had run afoul of the statute and recommended certain controls be implemented to ensure that future check cashing would not inadvertently cause the company to become a regulated financial institution under the law. The company adopted that policy, which I understand is Sterling Exhibit 2 in this hearing. Additionally, if I can, as we're talking about the racetrack, and even though it's not quite on point of this hearing, on behalf of Suffolk, our employees and our patrons, I'd actually like to thank the commission, the racing division, for your solid and cutting-edge role in supporting the heightened safety, integrity, and fairness of racing. Chip takes great pride in our trying to do the right thing every day, and your staff has made that an easy job. I'd like to thank you for your time, and now I'd like to turn this over to Chip.
Excuse me, if you have any questions, Commissioners, for Mr. Baker, go ahead. If something's come up I have to take care of for 1 second, then we can go ahead with the rest of it.
I actually had a question, Mr. Baker. Can you expound a little bit more on the process you described relative to the vetting by the cities, if and when you identify an operator?
Sure. So we have two separate host community agreements. They each have different requirements. We're obligated to follow each of them and each of their commitments. As a threshold matter, those are very hard negotiated documents, and they're very extensive in terms of the commitments. Threshold matter, we're on the hook for honoring all those commitments, and Suffolk's going to do that. In practice, there are certain things: number of employees you're going to hire, local purchasing, the quality of the facility, that the operator needs to have to be on board of and separately covenant. So our plan and what the cities expect from us, what the cities expect from us is that we will identify the operator, make sure that the operator can assure the cities that they have the capacity and the willingness and the agreement that they will honor those commitments. So we're gonna, before we sign up anybody formally, we'll be obviously working with you all on the qualification standards and working with the cities in terms of making sure they have the capacity to comply.
And you mentioned you cannot guarantee at this point that that process will culminate prior to the election. Was that a fair statement?
That's a fair statement. We are in negotiations with a number of parties, but this is a complex. It's a complex negotiation, obviously, to find somebody who would be able to fill these shoes and do the first-class job that the Commonwealth expects.
Mr. Baker, I had a question about your statement that you were going to work with the IEB on an orderly divestiture of the 4+%. Does that mean you'll be coming to the Bureau with a plan, and do you expect Caesars to participate in an amicable manner?
Yes. Yeah, in both events. Yeah, we sent a termination notice yesterday because we wanted to assure you today that Caesars had no ability, and Caesars agreed with this, that they had no ability to control or affect the applicant going forward. But we are having amicable business negotiations as to an orderly dissolution, and Karen and Catherine probably get sort of sick of this, but anytime we have an update, we call them and let them know, and we will continue to do that.
And do you expect that to be done in a reasonable timeframe?
I hoped we would have a plan last night. Poor Brian Conley here was up till 3 in the morning. I had to get some sleep because of this morning, but we'll continue to work on it, Commissioner.
Thank you.
Is the divestiture dependent on identifying a new operator? In other
It is
words,
not.
a replacement?
It is not.
Or can they be independent?
It's completely independent.
Mr. Baker, picking up on Commissioner Cameron's question, as you're going through the search process, ensuring suitability for license for a new operator in partnership with you, you're going to work in real time with the IEB, which we appreciate. You're appropriately conducting our own due diligence. Understanding the matter you just went through, are there additional steps in your due diligence that you're taking, obviously beyond working with the, through the IEB with anybody who's already been found suitable or was in the suitability review process? But any additional steps you're taking with respect to a due diligence review of a new operator?
Well, I guess, as you might not be surprised, I spent a lot of nights sort of thinking about what we could have done differently in this event. And given that, there are some things we're doing that are a little different. When we signed up Caesars at the beginning, this commission didn't exist. So who we could have vetted things with was a different matter. For people who are in the pipeline now, we've got this, we're going to insist that they let us deal with the Bureau, and we're going to insist that all relevant documents be turned over to us so that we can independently evaluate them. For people who aren't in the pipeline, we're going to make sure that they get into the pipeline right away if we get to the level of serious consideration. Other little protocol matters, given the nature of the notice we received, I will work out a protocol with the Bureau where if one of our qualifiers sends them a matter related to suitability, that they know that we're required to get a copy of it so that this matter couldn't have happened again.
Mr. Baker, there are references in undertakings, really, in the host community agreement involving World Series of Poker. They appear in a number of places in the agreement and in the appendices. How are you going to deal with that?
So there are a number of references to Caesars and the Caesar standards in the agreement.
Well, there's actually a commitment to build a World Series of Poker room or rooms.
Right, and we've talked to the city of Boston about that, and they understand that we are not going to be doing that, and that we will have a poker room that will be of that standard and of that quality, but it won't be branded as a Caesars product. We're going to notify the voters of that in writing, along with other matters that were notified in the summary this week. And we can make a copy of that notification available to you today, obviously.
Did the existence of the World Series of Poker is a highly recognizable brand in that segment of the industry? Did the existence of that brand and the ability to use it play a significant role in the financial projections for the operation of the facility?
Not to my knowledge. I know that to the extent, yeah, actually, I'd say no. To the extent that there was any relevance in the financial projections, Caesar's experience, but I think this would be true for any operator in an urban environment. There's more of which is more table game revenue, generally, not just poker, and less slot machine revenue, and we would anticipate that would occur with any operator.
There are also references in the agreement and the appendices to Caesar's facility in Las Vegas as a measuring rod, a measuring stick, if you will, for the quality of the development at Suffolk. How are you going to deal with that?
We're gonna meet that standard. We assured the city in our negotiations that was our minimum benchmark, and that we would meet or exceed it, and we still plan to do that. It's a little tricky in the sense of you're designing a project that is based on somebody superior to somebody else's brand. But we have all the drawings, all the specs. We are, I guess you might not be surprised given, you know, how long Suffolk's been at this, but we are very far along in design and construction drawings that we're actually showing in real time to our permitting authorities in the city of Boston. Those design and construction drawings and the related operating covenants will meet or exceed those standards. And we retain possession of those design and construction documents. They're our property, and we're going to use them.
So the withdrawal then, if I understand you, of Caesars doesn't affect the physical plant you envision?
It does not affect the physical plan or the I can't tell you that another operator won't, you know, want a different sign or might want the fountain to
No,
look
I
differently,
understand.
but in general, the quality will remain the same, sir.
Thank you.
Others?
Just one more on timeline. Do you expect that you'll have an operator identified prior to the next commission deadline, which is the end of December for?
Yes.
for
Oh, no,
us to-
we fully expect that we will have an operator identified and who will be our partner in finalizing the RFA2 submissions we will make to you.
I don't think this was asked in my absence, but the Bureau's report talked a lot about the process at Caesars and their compliance process, about how particularly the Gansevoort issue was reviewed. You were delegating to Caesars the role of compliance for this facility. What did that tell you about the compliance process? Is there anything to be learned? How are you going to delegate that now? To whom will you delegate that now? How will you? Are there issues that you saw in their compliance process that need to be addressed? That would maybe be for others besides you.
So, yes, so we're gonna, yes, we have learned from that, learned a lot from that. We're gonna work out a protocol we'll submit to the Bureau and you as to how we do this going forward. I'm not gonna presume we're gonna get it all right, which is why we're gonna need some guidance. We're gonna have our own independent compliance committee. Would recommend it be 3 people who are completely independent, who have knowledge and background in law enforcement, finance, and accounting, or, you know, related disciplines. We're going to tighten up in real time the reporting that happens between our operator and us in the Bureau. And we're going to insist that any written correspondence to the Bureau from our operator of any of our qualifiers that gets to the Bureau, we're immediately notified about. When we were working with Caesars, the issue really is at what level, when an operator learns something, do we need to be told? And so we're going to make sure that that's a pretty low level, so that we in the Bureau have every ability to react in real time to any issue that occurs at the facility.
And there's something about the makeup of a compliance committee and how it works, and we've dealt with this with other conversations. And, you know, I have two points. One is, number one, I'm very mindful of not sounding holier than thou in these conversations. You know, I've been in business, I've been in government, I've been in politics, I've made mistakes. You know, I understand how when you are in the midst of operations of business or government or politics or whatever, pressures are intense. I totally get that. But this is a uniquely vulnerable industry. And any industry, banking, medicine, certainly politics, gets insular. And standards become sort of what we all talk about to one another. And they, therefore, tend to slide. And it just goes with the nature of things. But having people in the compliance committee role whose job it is to say the unpopular thing, as a lifetime CEO, you know, it's a pain in the butt, but it's nothing more valuable than somebody whose job it is to say the unpopular thing, and going out of one's way to make sure that you structure an environment where you empower such people is the only way, given how insular all our worlds are, that you can protect against slipping, you know. And as I read the compliance report, as I read the Bureau's report, the compliance committee itself would have, now that it knew the full story, would have had it be done differently. But somehow there wasn't the intensity of the rigor that was there. And we would simply ask you and as we have talked about with other applicants, that's a really critical part of the process of catching what to the public might appear problematic things, never mind, might be problematic things. So all of us learning from that and trying to implement it in our operations as we have to do it in ours. I hope we have people in our operation who are empowered to tell us when I'm making mistakes, but it's a critically important part of this process in this very, very vulnerable industry.
We couldn't agree more, sir.
Mr. Chairman,
And
with
across, yes.
the Commission's permission, the Bureau just has a very few questions about the due diligence process that Sterling Suffolk went through before it first contracted with Caesars, if that would be appropriate
Sure.
at this time.
Yes, it is.
And probably I think the questions are most appropriately addressed to Mr. Baker. You described briefly in your testimony this morning, Mr. Baker, the due diligence exercise that Sterling Suffolk initially went through before it first entered into an agreement with Caesars in 2011. And you referenced that Sterling Suffolk knew that Caesars was licensed in dozens of jurisdictions.
Yes.
And you testified that you were aware that they were currently going through a suitability type proceeding in Ohio that you were able to follow.
Correct.
And that you had also reviewed Caesar's SEC filings to learn more about Caesar's financial viability to undertake this project.
Right, and also as you know, that if there's a material issue relating to compliance, that should also be disclosed in the SEC.
That it would
filings.
be flagged there, correct. So you mentioned briefly the comments in the report about Sterling Suffolk's compliance plans on page 37 of the report. There's a compliance plan, an employee code of conduct, and it looks like also there's a process that Sterling Suffolk had in place as of 2007, and I'm presuming had in place as of 2011, correct?
Correct.
To vet not only employees, but also potential business partners?
Correct.
Okay. Now, was that, and I take, can you describe to me what that would involve, the vetting of a potential business partner for Sterling Suffolk during this time frame?
Sure, so anybody who we're playing the contract with who's, I think we actually pretty much do anybody who we have a contract with, but the standard's $50,000. We put through a vet, which basically means we do a record check in terms of, LexisNexis search for any sort of questionable information, and anything we can find from public records relating to those kind of people and that's what we've been doing. So whether it's the contractors we're hiring, the architects, any of the vendors who on a going forward basis we're using.
Okay. And did that happen in connection with your initial vetting of Caesars back in 2011?
Yes, sir.
Okay. And who at Sterling Suffolk would have been responsible for that?
I would have, sir.
Okay. I take it that when Sterling Suffolk was initially contemplating the relationship with Caesars, Sterling Suffolk didn't hire a third-party investigator or a consultant to do a review?
We did not.
Okay. And I take it that Sterling Suffolk didn't prepare a written due diligence report or compliance report on Caesars?
We did not.
Okay. In following, the first agreement with Caesars was signed in March of 2011, and that was the subscription agreement at that point, correct?
Correct.
Okay. Following that point, was there an effort to do any continuing due diligence of Caesars on the part of Sterling Suffolk?
So not really until we started the suitability process.
Okay.
Although I would say in real time, John Payne, who's our board member, Sue Carletter, who's the director of compliance, Paul O'Gara.
These are
These are all
individuals
Caesars.
associated with
These are
Caesars?
would regularly inform us of various matters that were going on. We had a protocol once we started the suitability review that each of the qualifiers would report, would have a weekly call where there'd be reporting about any issue that might or might not be proceeding. And Bruce
And when you say,
Barton-
let me just stop you there for a second. So you, a report about any issue, would be, the qualifiers would report in on this call about who, maybe they got interviewed, or there was a request for documents or material of the like?
Correct.
And did that happen with respect to Caesars when the suitability investigation began? Did Caesars volunteer to the Sterling Suffolk team issues that were ongoing in the investigation?
Yes, but obviously not in a complete way.
Okay. Who was it at Caesars who was participating in these regular briefings, as it were, conference calls?
It would depend. Regularly, Sue Carletta and Paul O'Gara, from time to time, Tim Donovan, Scott Wiggin. I can't say there weren't others, but those would be the principal participants.
Okay. And Mr. Baker, would you be the person at Sterling Suffolk who would most regularly participate in those briefings?
Yes.
Okay.
Bruce Barnett or I would be on every one of those calls.
Okay. I take it from the chair's earlier question that this issue with respect to the Gansevoort license agreement never came up in any of those calls.
It did not, I never heard, I won't say that. At some point before this, we were told there was some issue about Gansevoort, but it was not described in any detail.
Okay. Do you recall when that was?
I don't, actually. I think it was, I don't. It was not anywhere near the May, April timeframe, though. It was, so.
I think in an earlier question, the chair referenced an April meeting at which the Bureau had expressed strong concerns about the Gansevoort issue. I understand that Sterling Suffolk. Okay, or I'm sorry. Let me rephrase that. There was some due diligence done by the Bureau's investigators of Caesars back in April.
Right.
At which the Gansevoort licensing agreement was the subject of some conversation.
Right.
And I take it what you're saying is that the reference in these periodic briefings to Gansevoort, when it happened, wasn't in April or May. It was sometime later than that.
I don't even know if it was even a reference in those things. I would be talking to Paul O'Gara, frequently, so I can't tell you when. I guess the point I would make on this, having reviewed the letter that was sent to the Bureau in May.
Okay. This is the May 31st letter from Mr. Donovan to Spectrum.
Correct. We had no indication when that letter was sent or at any time up till October 2nd of the weight or the seriousness of the underlying issues.
Okay. Do you believe, and again, I want to go back to this reference to Gansevoort that someone associated with Caesars may have made. Do you believe it was prior to May 31st?
No. I don't recollect that.
Okay. Sometime during the summer of 2013?
I'd be guessing, but that would be my guess.
Okay. So your best recollection for this commission that is at some point prior to October 2nd, there was a reference made to you by Caesars about Gansevoort, but that's all you can recall?
That's all I can recall.
Okay. Do you have a copy of the suitability report handy? If not, I can give you. Oh, perfect. Thank you, Karen. I want to draw your attention to pages 247 to 250, and this is a description in the report of the Terrence Watanabe matter that you've spoken about briefly. Are you there?
Yep.
Okay. Did you read that section of the report when it became available to you?
Yes.
Okay. And there's a reference in the report This is on page 247 in the last full paragraph, a reference to, in the report, to the fact that, in the last full paragraph, second line, Watanabe accumulated unpaid gambling markers in the amount of $14.7 million during the period between September and December 2007. Do you see that?
I don't, what page, I'm sorry?
I'm sorry, 247.
Okay, yes.
Okay. I guess this is, the Watanabe incident described in the report is referring to something that took place back in 2007, correct?
Right, yes.
Okay.
Yes, sir.
And there is a reference on the next page. I'm sorry, there's a reference on that page in the following sentence to a December 5th, 2009 article in the Wall Street Journal about Mr. Watanabe's gambling at Caesars.
Yes.
Okay. And then on the following page, there is a reference to a November 2009 civil suit filed by Mr. Watanabe against Caesars alleging a variety of misconduct. Before you saw the report from the Bureau, were you aware of the Watanabe incident?
Chip and I actually talked about this. I think we were aware of the Wall Street Journal article.
Okay. Do you recall when you became aware of it?
I think we became aware of it when we were vetting Caesars.
Okay, initially, back before
Yeah,
you signed the
yeah,
subscription
yeah,
agreement? Okay. Do you recall how it came to your attention?
We were just doing an internet search of, relevant public, and we just do that whenever we're gonna, before we do a meeting with somebody, the 10 days, just research them to see something about them.
Did you then follow up and talk to anybody at Caesars about the Watanabe incident?
I can't recollect whether we did that before or during or after, but yes, we did talk to people at Caesars about what happened at Watanabe, and we were assured that, that they had, there's a lot, Tom actually managed this matter on from October 2nd on, so all the information that the Bureau had available to it about the internal reviews of Caesars, we weren't privy to any of that until this window. What we knew was, so a number of the matters in here that relate to the nature of what happened, we were unaware of. We knew that there was this guy who had, these unpaid markers. We knew there was this story. We knew there was a lawsuit. They told us that they were resolving these matters with their regulators in Nevada and New Jersey, and that was the extent of my knowledge.
Okay, and again, these are conversations that took place prior to March 2011?
Correct.
Okay.
Well, contemporaneous, I'd say.
Okay.
Okay.
How about the Mitchell Garber episode that's addressed in the report as well? When was the first time you became aware of that?
We were aware of the Mitchell Garber, in one of the calls that we did prior to the October 2nd meeting. So it was a weekly call. I couldn't tell you when, maybe August. I don't know when the Garber interview occurred, but it was probably around then. I asked on the call whether any of the qualifiers had anybody sworn sworn in their interview, because that would have, to me, indicated a level of seriousness in terms of the Bureau's investigation. And Caesars informed me that Mr. Garber had sworn interview.
Okay. A conversation that took place sometime in the summer of 2013?
That's my recollection.
Okay. What's that? Okay. In connection with your vetting of, potential current partners moving forward, you talked about partnering in real time with the Bureau once you've identified another partner. What about, is you're reviewing, the candidates that you'd like to team up with before the Bureau gets involved? You do anything differently than you did in the vetting of Caesars in 2011?
Yeah, obviously. I mean, look, one of the things that guides us here is, we're very much benefited by the fact that the commission exists, the Bureau exists, that there are standards and rules now. So, and we believe, it's like the way Chip runs the racetrack. We believe like you work with your regulators in real time. So, you know, when we have any question about anything, there's a back and forth between us and the operator and the Bureau and the commission staff, and we continue that. I also think that, you know, a lesson I learned is that we would require people to deliver us copies of actual real documents and not just take, you know.
The public record for,
Yeah, and look, I take everybody at their word, so I'm not saying, you know, I'm not saying that anybody deliberately misinformed us, but I think that being able to get actual copies of submissions would have made a difference then, and we will insist on that going forward.
no further questions.
Anybody else?
Yes, I want to pick up on the Watanabe matter for a minute. So you read, if I understand you correctly, the Wall Street Journal article as you were vetting Caesars. You saw in that article not only that the unpaid markers were $14.7 million, but that Watanabe, in the space of about 13 months, had lost $127 million at Caesars, right?
Correct.
And you read about his allegations that he was provided alcohol and drugs even during the course of this losing spree, right?
Right.
And you talked to Caesars about that. And what did you say to Caesars, and what did they say to? Well, let's back that up. Did you also read in that report that at the time the Wall Street Journal article was written, that there was an investigation of this incident being conducted by the Nevada Gaming Commission?
I'm not trying to not answer your question. It's hard for me to remember what I knew then versus what I might have known.
At some point, did
Right,
you
right.
learn that there was during the vetting process, did you learn that there was an investigation being conducted by the Nevada Gaming Commission?
We either learned it during the vetting process might have been months after, but in that window.
And did you learn that the investigation was ongoing and it had not been concluded?
I can't remember. I can't
Do you
remember.
know whether it's been concluded today, by today?
We were told it was concluded, and we were told that it was resolved to the satisfaction of the commission in both Nevada and New Jersey by Caesars.
And did you learn, when you read the article, that with respect to the $14.7 million in unpaid markers, in addition to civil proceedings, Caesars had instituted, or caused to be instituted, criminal proceedings for unpaid debts against Watanabe?
I don't, that specific fact I don't recollect.
Would that have been of concern to you if you had learned it?
Yes, sir. I mean, I mean, it's not anything we would engage in.
Is it the kind of conduct you would want your partner to engage in?
No, sir.
And at some point after reading the article, you made a decision, and after the vetting process was concluded, that you would place Caesars in charge of compliance.
I guess I don't, that's not the way, I guess I don't, that I guess I don't agree with. What our plan always had been, and we feel really strongly about this, that the applicant is Sterling Suffolk. And we always expected that this commission would hold us responsible for anything that happened. And so we always recommended, Jeremy Klein and myself, we always recommended to our board that we needed some kind of separate mechanism to ensuring compliance of the licensee and the applicant. So as a practical matter, we knew that there'd be a Caesars compliance function at the facility. But we always then and continued to insist that there be some protocol where a Sterling Compliance Committee would get reports in real time and would separately evaluate and make recommendations and report to the Commission and the Bureau. So, yes, because Caesars was the operator, we expected that they would, and by the way, they insisted, they have their own compliance function. They said, look, we have our own compliance function, we have to follow it. We're going to do our own internal reporting up to Caesars chain. And we said, great, but when something gets to the level where it's getting reported up that chain, you have to report it to our compliance committee. And so that was the plan, even when Caesars was the operator.
But if I understood you today, you are saying that your intention is to form a compliance committee, and you're going to need the commission's assistance to form that committee.
Well, I wouldn't say,
Or not as assistance, but...
guidance,
Right.
yeah, guidance, yes. Yes, sir.
So that committee remains an inchoate ideal at the moment.
Correct, and I'll take any advice you all have to offer seriously, but I think our thought would be to lay out something in the RFA2 process that you could react to.
What documentation or plans or other information did you get from Caesars to assure you that a Watanabe-type incident would not recur?
We were told that they had reviewed the incident, they had self-reported that they learned many lessons from that incident, that they had put new procedures in place to deal with incidents like that, that they had resolved their lawsuit with Mr. Watanabe, and that, my recollection is at some point they just said, look, we have procedures in place that could not happen again in this company.
And did you probe to see what those procedures were?
Yes, I mean, in terms of the hierarchy of reporting, the fact that business people had to check with the compliance people and the general counsel, it was a long time ago, but the answer is, yeah, we did.
And did you get documentation with respect to those procedures?
I don't believe so.
Thank you, sir.
Thank you.
One other quick question, Mr. Baker. I think the question was raised earlier. In finding a new operator, do you expect that new operator to have the same percentage of ownership and also a seat on your board? Expect that, obviously. I don't expect you to speak for the whole board.
That's been a basis of some of the negotiations, but it could be another format. We're not, we're wed to making sure that somebody honor our commitments, make sure that everything we're promising happens, make sure that, the vision we have for this facility occurs. It may be that governance is not a factor, although I would say that the assumption is that would occur.
Anybody else? Yeah. Before we get to the next speaker, we'll take a quick break and try to be back in 5 minutes or so. Okay, ladies and gentlemen, I think we will reconvene at 11:15.
Want your mic there?
You'll take your seats. I think we will go to Counselor. It's your turn.
Thank you, Mr. Chairman. At this point, I present Chip Tuttle, our CEO.
Excuse me 1 second. Excuse me, if we could have everybody's silence, please, and take your seats. Yes.
Our third witness this morning is Chip Tuttle, Suffolk Downs COO.
Thank you. Good morning, Chairman Crosby, Commissioner Stebbins, Commissioner Zuniga, Commissioner Cameron, Commissioner McHugh, members of the Gaming Commission staff. I'm Chip Tuttle. I'm the Chief Operating Officer of Suffolk Downs, a position I have held since 2007. As Charlie mentioned in his introduction, I plan to give you an overview on our public communications efforts since we began the process of removing Caesars Entertainment as our gaming operations manager on October 18th. First, it may be helpful to tell you a little bit about our approach since we began talking in earnest about developing our 78-year-old racetrack into a world-class destination resort. We began our efforts to earn a gaming license with a commitment to set the standard for gaming development in the Commonwealth. Whatever the competitive environment, we knew that by setting the highest possible standards and focusing on the merits of our own project, we could be successful. From the beginning, we worked to set the standard for community involvement and an inclusive process. I was at a public meeting last week in East Boston where the president of the East Boston Chamber of Commerce mentioned that it was the 55th public meeting or forum she had attended on our proposal. I don't have the exact number, but if she's been to 55 meetings, I'm fairly certain that I've been to more than twice that many. These meetings and this dialogue with our neighbors have helped shape our plans. We also strive to set the standard for design, for creating an unparalleled guest experience, and for our commitment to sustainability to our natural environment. That is reflected in our goal to be the greenest gaming development in the United States, if not the world. We're working to set the standard for ensuring that our host communities and the surrounding areas share in the economic benefits of our proposal by partnering with local businesses and attractions and by signing the most comprehensive and generous host community agreements in the Commonwealth. We have used the same guiding principle since we asked Caesars Entertainment to withdraw as our gaming manager on October 18th, launching an aggressive public communications program to inform local residents and voters of the change. Here are some details of that program. Having sent the letter to Caesars asking the company to formally withdraw, shortly after 9 p.m. on Friday, October 18th, we distributed a copy of that letter with an accompanying statement by me to our media lists, which include all of the major local news outlets, and to community leaders in Boston, East Boston, and Revere. That same evening, we sent 12,046 emails to individual addresses in our email database. We posted a notice and the letter to the homepage of the Suffolk Downs website, to the homepage of the website of our campaign organization, Friends of Suffolk Downs. We utilized social media as well, with postings on the Suffolk Downs Facebook page, the Friends of Suffolk Downs Facebook page, and the Spanish language Amigos de Suffolk Downs Facebook page. We tweeted from the Friends of Suffolk Downs account, and I tweeted from my personal Twitter account with a link to the website and the notice. That tweet was retweeted by others, including members of the local media. On Saturday, October 19th at 10 a.m., I attended a public meeting at Revere City Hall that was also simulcast on local public access cable and has been replayed since then, where I explained in detail our decision to ask Caesars to withdraw. That same day, we posted a video explaining the change in gaming managers to our affiliated websites, Suffolk Downs, Friends of Suffolk Downs, and Amigos de Suffolk Downs, and on YouTube. In the 1 week period after it was posted, that video was viewed more than 40,000 times in 1 week. In addition to the letter and the statement to the media released on October 18th, in the days after, we conducted several briefings with members of the media and granted print, radio, and television interviews to local and national media outlets, including the local ABC, CBS, NBC, and Fox affiliates, New England Cable Network, Univision, WBZ Radio, WBUR Radio, the Boston Globe, the Boston Herald, and the Wall Street Journal. We held a briefing at Suffolk Downs on Monday, October 21st for the editors and reporters of our local weekly newspapers, the Revere Journal Transcript and the East Boston Times, to ensure that they had the most up-to-date and accurate information to report to their readers on our change in gaming managers. On Monday, the 21st, I was a guest at the Orient Heights Neighborhood Association monthly meeting, where I again covered in detail our decision to sever our ties with Caesars, including a chronology of the steps that we took in the month of October once we became aware of issues regarding its suitability. I attended 3 other public forums last week where we discussed the issue in depth, and another last night in Revere. We started a local television campaign on Tuesday, October 22nd, with a 60-second commercial on both cable systems that cover East Boston and Revere to continue to let local residents know of the change. We supplemented that cable campaign with a Spanish language spot on Univision and Unimas Hispanic TV, and with local network spots in Fox pregame coverage of the World Series. On Wednesday, October 23rd and Thursday, October 24th, we ran print ads in the East Boston Times, the Revere Journal, the Revere Advocate, El Planeta, and El Mundo newspapers to ensure that their readers were informed of our change. Those same 2 days, we leafleted 6,242 houselets in East Boston and 10,896 households in Revere, specifically targeting 9,370 voters in East Boston and 17,230 in Revere, respectively. We mailed 19,497 postcards to residents in both communities. This past weekend, we released to the media our plan and guiding principles that Charlie covered as we work with you in a timely manner to secure a new gaming operations partner. This week, we are mailing a formal notification to East Boston voters on the removal of Caesars as our partner to ensure maximum awareness of this prior to our scheduled ballot questions November 5th. Since taking action on October 18th, we have worked to communicate that action to the public and to ensure that local residents and stakeholders have the benefit of an open, inclusive dialogue that we've tried to maintain throughout the multi-year process of working to earn a gaming license here in the Commonwealth. I will now, if you don't have any further questions, I'll take questions or turn it over to Chairman William Mulrow for the next phase of our presentation. Thank you.
Are any questions from the table, from the council?
No questions from the Bureau.
Commissioners?
I do have a question. The community meetings or the public meetings that you just described, would you characterize the questions that you might get at those meetings?
Commissioner Zuniga, yes, thank you. The questions come in two forms, basically. I think people and residents want to be reassured that even though we are seeking a new gaming management partner, that our commitments remain the same, that our commitments in our host community agreements and the commitments we've made to our neighbors for the last, since we started this discussion in the summer of 2007, that those all remain in place. And I'm happy and able to reassure them that that's the case. I do think there is a little bit of confusion occasionally because other developers in the Commonwealth, the gaming company is the owner, is the developer. And in our case, Suffolk Downs is the entity seeking this license, not Caesars. The other question comes in the form of wanting to be sure that the brand standards that were discussed earlier remain consistent. And I'm happy and able to reassure people that those remain consistent, that the project is still in excess of $1 billion, that all of the drawings, all of the renderings, the plans that we have presented in the community since June of 2012 remain in effect, that we are in fact in the state permitting process and started the process with the BRA, and that our commitments to the level of quality remain completely intact and in force.
Mr. Tuttle, to this point, how much money do you think you've spent on advertising, leafleting, kind of getting the word out about the change just in the last few weeks?
The budget over on this in particular is $50,000, $60,000 just since since we started the process of severing our ties with Caesars on the 18th. It ultimately will be more than that once we're finished with the process.
I have another question. It's somewhat not necessarily related to the topics you just touched on, but can you just give me a quick update as to Suffolk's consent decree with the EPA, just in terms of progress, any issues that have arisen? How long is the consent decree, I guess? Number of years for that settlement?
Yeah, so Commissioner Stebbins, I'm going to defer to Charlie Baker on that and let him take that question.
There's an ongoing monitoring Commissioner, but the consent decree is basically resolved. As you may know, we were first approached by them in 2007. It took us and the EPA a while to figure out how to deal with this issue. Having 1,000 horses in a place makes you a combined animal feed operation. Almost universally, the combined animal feed operations around the country are like stockyards, or, you know, they have very specific rules for pigs, chickens, other kinds of livestock. They had no specific rules for horses, so it took us a long time to work out a mechanism and a plan to do this. The EPA signed off on that plan in 2012, and the only obligations we have on a going forward basis with them is reporting and monitoring, which we do quarterly.
I know there was a fine paid, but there were some other projects you had to invest money in on the site. What was the total amount of kind of those projects, if you know off the top of your head?
I think it's $2.1 million.
Okay. And is the monitoring for the foreseeable future, or is it for a certain period of time?
It's for the foreseeable future. It's until the EPA tells us to stop. We report both to the EPA and to the MWRA.
Commissioners? Do we have a copy of the leaflet that you distributed? Is it at one of our exhibits?
If it's not one of the exhibits currently, Mr. Chair, but we're happy to get you copies of all the materials that we have used in our public communications.
Particularly the door-to-door leaflet. As you know, we're talking about a related issue at 3 o'clock, and I'd be interested in seeing that if we could get copies of it by then. Anything that's gone out really directly to the citizens. This is a little bit similar to the question that I think Commissioner Zuniga asked you, but if you put yourself in the mind of a voter in East Boston who knows what they tend to know, not terribly strongly on either side, just kind of trying to figure out what to do here, what is there substantive that voter, or is there anything substantive that voter won't know? Is there anything under these new circumstances that impedes that voter to make a good judgment on November 5th, an informed judgment on November 5th?
I don't believe so, Mr. Chair. And I have had hundreds of direct conversations with those folks since October 18th, including knocking doors this past weekend. And in the community, because of our 78-year legacy in the community, they are very familiar with Suffolk Downs as an entity and as a neighbor. So being able to reassure people that our commitments have not changed, I guess one conversation may sum it up, but if this was with a gentleman that lives in the Orient Heights neighborhood, but if you thought 4,000 jobs with local hiring preferences was a good idea 2 weeks ago, you probably still think it's a good idea this week. And if you thought all the other commitments that we've made to local spending, to the quality of the facility, and preserving the 78-year-old sporting landmark in the neighborhood, all those things, the change in operators hasn't seemed to change anybody's point of view.
Okay. Next.
Next is our chairman, William Mulrow.
Chairman Crosby, members of the commission, my name is Bill Mulrow. I serve as chairman of Sterling Suffolk Racecourse. On behalf of the company, let me add my thanks for giving us the opportunity to appear before you today. As the person who is ultimately responsible for day-to-day corporate governance matters, I thought it would be helpful for me to tell you something about my background. For the past 3 decades, I have served in senior executive positions in both the financial services sector and in government. I'm presently a senior managing director and partner at the Blackstone Group, which is the world's largest alternative asset manager in the areas of private equity, real estate, credit, and hedge funds. Before that, I served in senior positions at Citigroup, Paladin Capital Group, Rothschild, the Global Investment Bank, and Donaldson, Lufkin, and Genred Securities Corporation. In addition to that work in the financial sector, I've had deep experience in government. I've been an appointee of 4 separate governors. I've run for statewide office myself, and I'm currently the chairman of several housing agencies that are the largest issuer of tax-exempt bonds to finance affordable housing. It's actually the largest financer of affordable housing in the country. Additionally, I was blessed with a good education, first and foremost from my parents, both of whom were immigrants from Ireland who came to this country in the late 40s. My mother was a waitress, my father a machinist. I grew up in a 5-story walk-up apartment building, and I was benefited through their eyes of learning about the importance of hard work, of working every day with integrity and honesty. And with their encouragement and support, I was able to get a more formal education. I received my graduate degree at the Kennedy School of Government at Harvard and my undergraduate at Yale. Since 2007, I've been the chairman of this company, and every day we have striven to do the best job we can with the highest integrity and the most transparency, and we have every intention of continuing to do that in the future. You've heard already from Charlie, from Tom Riley and Chip, and I do not want to repeat what they said, but I do want to emphasize that this company, and I personally, take matters of compliance, integrity, and transparency very seriously. I believe this company, as long as I have been involved in it, has a demonstrated history of working closely and cooperatively with our regulators and our community partners, the cities of Boston and Revere, and of generally being a good neighbor. When I first became involved in this project in 2007, I learned about the great wellspring of community support Suffolk Downs had engendered over the years and which still exists today. Nothing has changed. As we have gone about the planning to bring this last New England thoroughbred racetrack into the next generation of gaming as a resort destination casino, what I've learned is that people want to know that we are going to build a first-class project, employ people at good wages, and integrate the project into the fabric of the community. We have assured them that we will. I'm here today to say to you that if given the opportunity, we will keep those promises. As I've mentioned, I've spent some time in the public arena and in businesses where trust, integrity, and confidence are crucial. I want to assure this commission, our city partners, Boston and Revere, our surrounding communities, and our other stakeholders that this company will honor every commitment it has made in our host community agreements and in our partnership commitments to local vendors and organizations if we are successful in earning your trust and being granted a gaming license. We at this table and our other qualifiers who are here in attendance today are available to answer any remaining questions. Thank you.
Counselor?
No questions.
Commissioners?
I had a follow-up question for Mr. Baker. The question I asked you earlier, sir, regarding the divestiture of the 4+, all of the interests
Right.
that Caesars presently, I know it's important to the Bureau, and I think it would be important for us as well to have some kind of certainty before we consider suitability with this matter. I know that you stated that you would hope today to have a resolution to this matter. I'm just wondering if we could consider a plan where, for example, within a week, you can have a report to the Bureau on this matter. I don't think we can let it hang out there indefinitely, frankly, and I think that the next step would be considering a divestiture trust if, in fact, the matter isn't resolved in a timely manner.
The answer is yes. I'm just trying to,
We talked about it, and you said in general that you were moving quickly, but I just think that this is a serious matter that we need to have some certainty.
You're talking about the formal, final disassociation of Caesars from...
This is the fact that, yes, Caesars is still a 4+%.
right. So we hope to have a voluntary agreement with Caesars. We hope to have it very soon. If we know that they've withdrawn as a qualifier, we know that their board member's been resigned. We know that we have removed them as a gaming operator and removed any special control rights that they have. Obviously, you know, I'll continue to update that. So the remaining issues are equity and their other financial, arrangements with the company. We are negotiating with them today. I just don't want to promise you something I can't deliver, and I know you don't want me to do that either. So I'm not trying to. Here's what I can tell you: that the minute we have a voluntary agreement, whether it's today, tomorrow, whatever, we will immediately get a copy of that to you. If we don't have a voluntary agreement within a week, what I will pledge to you is we will tell you the action steps that we would recommend that you consider with us in terms of a divestiture trust, and how we would direct that.
I'd say it'd be important for you to have a report ready within a week for the IEB, and at that time, next steps can be reported to us. But I just think we needed to be more certain. When you say they're not a qualifier, they're not a qualifier because
Yeah.
they would be completely divested, and that hasn't occurred yet, so.
Happy to do that. And let me just say, you know, we're not, I'll speak for myself, I'm not perfect. And if, you know, if there's some guidance or some direction that you feel, you know, we need to take, you know, I'd welcome any, you know, any guidance. So, I mean, I think you've given me enough on this matter, but I would just speak about that generally, so.
And I'm happy to work with the applicant to make sure that that takes place, because I agree with Commissioner Cameron that there needs to be some certainty as to that matter, not only for their 4.2%, but also their preferred shares, so that needs to be addressed. And I just want to clarify one thing for the record. In my remarks, I mentioned Joseph O'Donnell. I had said CMIC representatives represented they would cover any unanticipated shortfall, but with Caesars out now, once this divestiture, it would rest with Joseph O'Donnell, which is still sufficient, but I just want to clarify that for the record.
Okay, thank you.
Thank you.
Anything else, commissioners? That segues to a question I want to ask Mr. Mulroy. One of the things we're getting at here, obviously, is the nature and quality of the process by which this applicant makes partnerships. And you have had, haven't had, a partner for, I think, some number of years, Vornado, who knew that you were going to be going in to be an applicant for the gaming business, presumably knew what that meant. And then along comes the background check process, and all of a sudden Vornado throws up its hands and says, whoa, no, this is unacceptable, we're not going to do this. What were you thinking? What happened? I mean, how could that come about?
Well, we had every intention of believing that Vornado was going to go through the background check process. We were equally surprised at I'd say the 11th hour when they had decided that they were not going to participate. So we had every intention from them of believing that they were going to do so. I think.
So they were aware of the process, and they had led you to believe that they would participate in it?
Yes. So this had gone on obviously for several months, I believe it was, and we all had plenty of time to prepare and put our own financials together. And at the very, very last moment, they decided not to go forward.
Okay. Okay. Anybody else? Let's see now. Are there any, so are you done in your presentation? Do I see something else?
One moment,
Sure.
please.
Okay.
Okay,
Do you have any further witnesses?
we have no further witnesses. I have a brief closing.
Right? Is there any further recross, redirect? Would the applicant like to make a closing statement?
Yes, Your Honor. Yes, Mr. Chairman.
Mr. Chairman.
Members of the commission,
Trying
thanks
to
again.
keep him in his place.
And you're succeeding.
I told my team that I was very excited to be appearing before Judge McHugh again. Members of the commission, thank you for your attention. Again, we appreciate the opportunity to appear this morning. We believe that Suffolk Downs, as the applicant, has met its burden of proving its suitability by clear and convincing evidence. As you heard from the Bureau, there are no issues of suitability with respect to the applicant or any of the current qualifiers. The only conditions raised by the Bureau with respect to Suffolk Downs relate to identifying and bringing on a new operator of the proposed casino project. And the matters of interest in your notice and memo about this hearing also pertain to removing and replacing Caesars as operator of the project. We believe that our witnesses have adequately addressed the matters that were listed in your notice. We believe that the evidence before the commission demonstrates that Suffolk Downs has responded to the results of the Bureau's suitability review of Caesars with the integrity, the honesty, and the good character that the suitability standard of the gaming statute requires. As you heard from Mr. Baker, when the company performed its initial due diligence of Caesars in 2011, it was vetting a public company licensed in many jurisdictions. It relied in particular on the then recent finding of Caesars suitability in Ohio. The company did the best it could with its due diligence with the sources of information available to it. It didn't have the benefit of the Bureau's assistance because the Gaming Act hadn't been passed, the commission didn't exist, nor did the Bureau. It did work with its then current regulator, the Massachusetts Racing Commission, to inform them of Caesars' involvement and to get them to vet and approve Caesars' representatives to the Board of Managers. Thereafter, as the company's qualifiers went through the suitability process, the company relied on self-reporting. It relied on Caesars' contractual obligation to keep us apprised of any suitability issues that arose. And we had, as you heard from Mr. Baker, weekly telephone conference calls where those matters were discussed. And unfortunately, those obligations were not met. There was also an element of trust here with a business partner, and unfortunately, that trust was not honored. As a result, the company learned of the issues identified by the Bureau and of their gravity, their seriousness, only at the beginning of this month. At that point, the company immediately retained Mr. Riley as special counsel, relying on his well-known integrity and reputation for good character. And as you heard from Mr. Riley, the company proceeded to act as quickly and as responsibly and decisively as it could in the face of very upsetting information by which I think Mr. Riley fairly used the word blindsided. And it took appropriate action as more and more information became known. And consequently, the status today is that Caesars has withdrawn as a qualifier at our request. Mr. Payne has resigned from the Board of Managers. We have taken the additional affirmative step of terminating the gaming facility management agreement, and we have officially removed contractually their seat on the board so that no one can replace Mr. Payne from Caesars, and we've taken away their voting rights. And all that does remain is their 4.2% equity interest in the company. And we are going to work just as quickly with the commission as we can to resolve that issue. But responding to Commissioner Cameron's suggestion that a finding of suitability be delayed until that 4.2 interest is resolved, we would respectfully urge the commission not to delay, but instead to issue its decision before the elections next week so that the voters can have the benefit of your view of the suitability of the applicant before the election takes place. As you've heard, this is a crucial issue now for us, and Mr. Tuttle has been living it, as he told you, working with the host communities and with voters to make sure that they know what's happening here. Because as Mr. Mulrow testify that Suffolk Downs remains absolutely committed to its host communities and to honoring all of its commitments under all of its agreements. As we go through our efforts to replace Caesars, we will, as the evidence indicates, learn lessons from what happened before. And as you heard from Mr. Baker, the company will require the replacement operator to waive confidentiality with respect to its suitability review with the Bureau so that we, in Mr. Baker's words, in real time, can be apprised of any issues of suitability. And we've learned also from this experience with Caesars that trust is an honorable virtue, but you can't rely on it entirely, and that compliance measures must be taken and strengthened and increased. And we, as you heard from our witnesses, the company will do that. We believe that the evidence that you've heard and the people that you've heard from should give you every confidence that the officers and managers of Suffolk Downs will honor all of their agreements with their host communities, and that they will, in every instance, strive to meet the very highest standards of conduct that you rightly demand from a potential casino operator. So we urge that Suffolk Downs be approved as suitable as an applicant, subject to the conditions related by the Bureau, which are one, that the applicant identify for the commission the new operator of the proposed casino project, that they be found suitable, and that we present a plan for working with the host communities to bring the new operator on board. But again, I would urge the commission on behalf of Suffolk Downs to make its decision with those conditions and find that Suffolk Downs is qualified as an applicant, and to make that decision with those conditions just as soon as possible so that we can apprise our host communities of that decision and they can have the benefit of the decision, hopefully favorable, before the election. I think that's fair to the voters and fair to us, and I think would benefit the process.
If I can just clarify, Mr. Falvey, I was not suggesting we delay suitability. I just thought it was important to have a plan in place as we proceed, and I believe we came to that agreement.
Then I overreacted or misunderstood. Anyway, I'm very glad
I may
to
not
hear-
have been clear.
Okay, I'm very glad to hear that, and I thank you for your attention.
Any final things? Thank you. Thoughts, questions, commissioners? Thank you, Mr. Falvey. With that, we will conclude this portion of the suitability hearing. The commission will deliberate about the matter in private and issue a written decision. The proceeding at this point, however, remains open. If at any point during deliberations the commission determines that further testimonial or documentary evidence is desirable, it may send notice of such to the applicant and provide instructions as to how to proceed. Further, all applicants, of course, have a continuing duty to provide updated information to the commission and the Bureau. So we will temporarily adjourn. I do want to remind folks that we have a separate meeting at 3 o'clock. There is no obligation for the applicant to attend that meeting, although it might not be a bad idea in case we have questions. And we would like to have any materials delivered directly to voters enough before that so we have a chance to take a look at it. With that, we will break for lunch.